the property management industry, fair housing offenses are considered especially troubling. In the United States, a dedicated fair housing attorney, Leslie Tucker, provides case explanations and best practices. These are some cases.
Hello, everyone. Welcome back to Case Files, where we review real fair housing cases to help property management professionals avoid costly mistakes. I'm Jonathan Saar, and with me, as always, is our resident fair housing attorney, Leslie Tucker. And today's case involves United States versus Rutherford Tenants Corporation and James Ramadai. I don't know if I pronounced his name right, so hopefully I got it close. So Leslie, this one covers emotional support animals, noise complaints, and retaliation, all rolled up in a nice bow and package of a multi-year dispute. So let's start at the beginning. What happened here?
So Jonathan, I refer to this case as the Parrot case. This case began with a unit owner, Miss Lesser, who had lived in this New York City co-op called the Rutherford since 1999. She had 2 parrots when she moved into her unit, when she first purchased it. And she informed the board that these were emotional support parrots, and they helped her manage, her anxiety and depression. From the time that she moved in up until 2015, which was 16 years, there were no complaints at all about noise. But that changed when she added a 3rd parrot to her household in 2015. The co-op's management began receiving noise complaints, allegedly from Miss Lesser's neighbors. Over a period of months, these neighbors or someone called multiple authorities to come check on the situation with the noise and the parrots. City inspectors conducted multiple unannounced inspections of her unit, 15 from the Department of Environmental Protection and 1 from the Department of Health. All of them resulted in no violations. They found really nothing out of the ordinary, nothing wrong with the situation.
Okay. So the case of the problematic parrots. This is what we're talking about today. Okay. Yeah. So the inspections didn't find any noise issues. So what happened? How did it escalate from there?
Yeah, so there were technically these clean inspection results, but this didn't change the fact that they were receiving complaints from the neighbors. So the board issued a notice to cure in March of 2016, essentially telling Ms. Lesser to get rid of her parrots. And her attorney responded with documentation from a healthcare provider, kind of confirming her disability and the need for all 3 of these parrots. The board allegedly rejected this request, calling it irrelevant and misplaced, and moved forward with the termination proceedings. That led to Ms. Lesser moving out of the unit. So she moved out in mid-2016, but she did still technically own the unit, so she had to continue paying utilities on it. And the co-op did continue with eviction proceedings for the next couple of years.
Okay. But this case wasn't just about the parrots, right? There was also a claim of retaliation.
Correct. Yeah. So in 2018, shortly after she had filed the HUD complaint, the board allegedly started adding large legal fee charges to her monthly statements, which at one point reached over $70,000. They did later, the following year, remove these charges. But then when Ms. Lesser attempted to sell her unit later in 2019, then the board allegedly rejected a qualified buyer without giving HUD any legitimate reason for rejecting that buyer. And that refusal prevented Ms. Lesser from mitigating her damages, right, and selling the unit out. So HUD investigated. They found reasonable cause for both discrimination and retaliation claims. And then the case went to the U.S. Attorney's Office.
Okay. So the parties did reach a settlement in this case. So what did the consent decree require in the end?
The consent decree, which was approved in 2024, included several components. One, that the co-op must adopt and post a written policy, train all their staff and board members, and of course, report to the government on all accommodation requests over the next 5 years. So that's kind of the standard part of all of these consent decrees. Then there was the monetary relief. The co-op was agreed in this consent order to pay the complainant, Miss Lesser, $165,000 for pain and suffering. And they had to offer to buy her shares for $585,000 without charging transfer fees or taxes. So essentially to buy her out of that unit. And if she didn't sell to the co-op, if she didn't take their offer, they have to allow her to sublet her unit without any fees and can't unreasonably withhold approval for later sales. So that was all part of this agreement.
Yeah, that's big. That's a substantial settlement. So what are the main lessons? Our audience, here's the teaching point. Class, listen. What are the main lessons for property management professionals?
You need to have a clear, reasonable accommodation process. This particular co-op did not have a policy at the time that all of this happened, which, realistically probably contributed to their legal exposure. Respond in good faith. So, dismissing a documented accommodation request without engaging in the interactive process, having a discussion, is a violation of the Fair Housing Act. Avoiding retaliation. So charging fees, interfering with a sale after someone files a fair housing complaint can certainly appear to be retaliatory, even if that's not how it was intended. So just be aware of the timing of these types of actions. And lastly, and I think this was really important in this case, evidence. Okay, having evidence to support the actions that you take. Noise disturbances, which were involved in this case, are a violation. Even if they're caused by an assistance animal, it's still a violation to have excessive noise. However, moving forward with an eviction due to these violations requires documentation and other types of evidence. In this case, multiple inspections by local agencies didn't find any kind of violation. So if you believe you have a legitimate reason to terminate a lease or to start an eviction, make sure you have solid evidence to back it up.
Great takeaways. Yeah. 4 key points there. So thank you so much, Leslie, for giving us your insights, and education helps our community out a lot. In this case, really shows how a dispute over animals can turn into years of litigation, crazy big payouts, and so much time involved in managing a case like this. So it's a good reminder for all of us. We need to train our teams, have policies ready, and treat accommodation requests seriously. So, Leslie, thank you so much for breaking this down. And to our listeners, remember, these real cases are meant to help you stay compliant and protect both your residents and your organization. So we'll be back with another wow, that's a tough real world example soon. Until then, stay informed, stay compliant, and keep building communities where everyone has equal access to housing. Take care.